Guys, all right, what I'm going to do is I'm going to talk about statutory law versus case law. And to do that, I'm going to get into Wikipedia. Now, if you just saw my little screensaver there and you're like, Mr. G, what in the world was that? Well, that was, I share an account with my youngest daughter so that I can track what she does. And she decided she wanted a Dory screensaver. So when she saved Dory, it linked into my computer. So my screensaver is Dory right now. I hope you got a laugh out of that. All right, statutory law versus case law. Now, if we look at the Fourth Amendment, I'm on Wikipedia here, we're just looking directly at the Fourth Amendment. The Fourth Amendment says it prohibits unreasonable search and seizures that require any warrant to be judicially sanctioned and supported by probable cause. It is part of the Bill of Rights that was adopted in response to the abuse of the writ of assistance, a type of general search warrant issued by the British government and a major source of tension in pre-revolutionary America. So first of all, we need to understand that when we create a law, it's to resolve a pre-existing situation. So the pre-existing situation was that before the Revolutionary War, the British government would issue these writs of assistance, which basically allowed British troops to go in and search anybody's property they wanted to, if they suspected them of all the things that was going on with the British government, tax evasion, all this other kind of stuff. So if they had a writ of assistance, then the troops could go in and search anybody's property or seize anybody's property that they wanted to do. And so the Fourth Amendment was put into the initial Constitution under the Bill of Rights to limit search and seizures to those things written specifically out in a warrant, supported by probable cause, and authorized by a judge. And I think everybody understands what the Fourth Amendment is. It was signed off in the law, added to the Constitution. So the Fourth Amendment is a statutory law. It's codified, which means it's been written into code. So this would be a statutory law. This is what is codified by Congress, and we know it to be law. So when you talk about case law, a good example of case law would be Terry versus Ohio. And in Terry versus, don't run away on me here. On Terry versus Ohio, what you had was in 1968, the U.S. Supreme Court heard the case regarding a person's Fourth Amendment rights against unreasonable search and seizures. And what happened in Terry versus Ohio, if you notice, we'll get with the Terry frisk or the Terry stop. And basically, it gave police officers the right to have a reasonable suspicion that someone has committed, is committing, or about to commit a crime, to stop a person and pat them down just to see if they have any dangerous weapons on them or fruits of the crime. So if you read all of this, this is the Supreme Court's decision in the case of Terry versus Ohio, which is 392 U.S. Section 1 from 1968. So this is the case. This is the decision. So what this does is this is now case law attached to the Fourth Amendment, which is statutory law. And it says that in attachment to this statutory law, case law also provides these additional provisions right here, where I'm rapidly doing my little icon. So this would be the case law. Terry versus Ohio is the case. And this is, it's like the amendment to the amendment. These are the additional case law factors that the Supreme Court case of Terry versus Ohio adds to the Fourth Amendment. So again, Fourth Amendment went through Congress. Congress voted on it. House voted on it. President signed off on it. Of course, it's Constitution. It's codified. It means it was put into code. It's a legislative act. and this is statutory law. Case law goes through the court system, court makes a decision, and then the factors of that decision become the case law regarding the Fourth Amendment. Okay? So I hope that's clear. If not, I greatly apologize. Just shoot me a message and we can talk about it more. Thanks.